Today, we're filing a false claim against the major tobacco companies in the amount of $133 million, which is subject to be trebled to $399 million. Let me just give you the background on how we got here, because it's somewhat complex and slightly tortured, let's say. I think you're all familiar with the MSA, the agreement that the state attorney generals had with tobacco companies over 24 years ago. That provided payments for indefinitely as long as they were producing cigarettes. And we've recovered to the state of Iowa payments of $1,410,000,000, $1.4 billion over the course of that time. A very significant amount of money that's been used by the state in multiple ways. But part of the agreement was that the tobacco companies that didn't join, all tobacco companies had the ability to join, not just the major ones that were part of the basic agreement. Others had the ability to join. But if a tobacco company did not join the agreement, they were required to make a payment into escrow in case they were sued. And the idea of the payment into escrow, there were really two purposes. One, the companies were concerned about a competitive advantage that those companies would have. And we on our side, we're concerned about cheap cigarettes. Cheap cigarettes are the enemy of public health, because more people buy more cigarettes in general, and particularly kids access cigarettes more often when they're cheap. So the states have, as part of the agreement, a responsibility to diligently enforce this escrow requirement, to require the non-participating manufacturers, as they came to be called, to pay into the escrow fund. And according to our petition, we took that very seriously. We worked very hard on that. Now, what could happen is that if the tobacco companies believed that we didn't, any state, Iowa or another state, didn't diligently enforce that escrow statute, they could file a claim against us and reduce each year the amount of money that's paid to the state. And just by filing the claim, they can throw the money into escrow or just not pay it and pay later with interest. So the states, had this concern that this remedy imposed upon them, or could be imposed on them, that could be a significant amount of money. There was just the amount of money that could be withheld as a result of failing to diligently enforce was very significant, and I'll describe that over the years. But the tobacco companies, to make that claim, should have some basis for saying that we didn't diligently enforce. So what happened was that for the year the history is this: for the year 2003, they claimed that all the states did not diligently enforce. There was the money was withheld from each state, and then we went through this process to determine whether we diligently enforced or not. And the process is a complicated one. It's a very impressive one. It's an arbitration panel of 3 former federal judges that make the decision. The problem is that one of the problems is that it just took a long time. And the 2003 case took 7 years, and we weren't paid until 2014, 11 years after 2003. The 2004 payment was also subject to the arbitration and the withholding, and that was just recently decided in September of last year, and we still haven't been paid. In other words, 18 years later, we still haven't been paid what we had coming. Let me just talk a little bit about the 2 decisions that were made by the arbitration panels. In 2003. Our office took the lead in a lot of the litigation in arbitration. Don Stanley, our great expert, was the main witness for the states in the common case and for our case to explain all the issues to judges that were brilliant, but very new to a very complex area of the law. Just reading the decision, or maybe it's our bias, but reading the decision, it looked like we had probably the strongest performance of any of the states. They litigated over about 10 states. To make this more complicated, there was a settlement with most of the states, a settlement that we didn't agree to because we thought we were giving up too much money and giving up risk of greater reductions in the future. So in 2004, the decision in September, again, we thought that, just reading between the lines, we had the strongest performance. And of course, we had Don Stanley, we had terrific lawyers that led the case. Roger Stone from 2003, Mary Culver for 2004. So, you know, the frustration is significant because of the amount of time and the amount of money involved. And as we alleged in our complaint, the really strong performance by Iowa, that there really isn't a basis for them to withhold. Iowa's false claim statute is relatively new, a few years old. We're working on it and we're implementing it. And there is this concept of a reverse false claim that's important in this context, that ordinarily false claims are claims that individuals or corporations file for money with the state and get the money or attempt to get the money. Here it was reversed. They were filing a claim to keep us from getting money that we argue owe us. We learn. I often talk that states are laboratories of democracy. We learn from other states, and in this case, we learned from Montana. Montana filed this similar claim a while back and received a very good settlement. They got all the money that was in escrow. They got some additional money. They got attorney's fees. They got a pledge that they won't withhold in the future if they make a claim. So we've hired the firm that did that work as outside counsel. That's been approved a while back. Tim Fox, the Attorney General of Montana at the time, and president of the National Association of Attorney Generals, is part of the team of lawyers that centers around somewhat Morgan and Morgan that is working with us on this case. So just an enormously complex case, but it comes down to their ability to withhold this money from us, a huge amount of money, $133 million over a large number of years, 18 years now in terms of 2014, in a situation where we argue that they don't have a basis to make that claim. With that, I'd be glad to answer any questions anybody might have, recognizing that the complexity that I've referred to repeatedly.
Thank you, AG Miller. If anyone has any questions, please use the raise hand function, or you can type your question into the chat box.
You know, I would just add a lot of thanks to the people in our office that have worked on this on diligent enforcement for so long. Matt Gannon is here with me today. Don Stanley is considered the top expert in the country on these kind of issues. Mary Culver is leading the litigation now, and many more people over the years contributed to this enforcement effort that we allege is, you know, pretty much rock solid is our allegation. And also we work closely with the Department of Revenue. They have been great allies in the diligent enforcement effort and in testifying in the first arbitration. So we thank them as well.
Great. I'm not seeing any questions come in. Oh, apologies. We have a question from a caller. Can you unmute your phone, please?
I don't know.
Sorry, we can't take your question if you don't unmute your phone. Okay, caller, unfortunately, we can't hear you. If you would like to send your question via email, you can do so to the media contact on the press release and the media advisory that was sent out yesterday to Lynn Hicks. Do we have any other questions today?
And I was going to thank the caller for the question, sort of. But it didn't work for some reason.
And just an ending note, a press release on this matter is currently available on our website. An email of the release will be sent out about 12:30 this afternoon. And we will also have a recording of the meeting available. Okay, with that, I think we'll wrap it up.
Thanks, everybody. Thanks.